All right, welcome back, everyone. I'd like to introduce our first keynote speaker. The feminist scholar and lawyer Catherine McKinnon is known for saying, "Law organizes power." We all know that our government doesn't represent us, but often we forget that we can reclaim the power of law for ourselves. Our first keynote speaker helps us bring that power back to where it belongs, in the hands of the people. He is the founder of the Community Environmental Legal Defense Fund, a nonprofit law firm that has worked in hundreds of communities across the country to pass laws revoking corporate rights, banning projects like fracking, mining, and factory farming, and recognizing the inherent rights of nature. Please join me in welcoming Thomas Linzey.
Oh, Jesus, it's the lawyer. You can hear people turning to each other. Hey, do you know if there's Wi-Fi here? So just type that in. So before I start this afternoon, just wanted to do some thank yous. It takes a lot of work to put these events together, as everybody knows, and not just for the speakers, but also Max, Cameron, Torin, Dylan, Saba, everybody that has helped put this event together and has done so for several years. You know, whenever I get together with Derek, it makes me think back to the first time that Derek and I got together, which was in Spokane, Washington, at the urging of a guy named John Osborne, is a physician in Spokane. And John worked with Derek on a book called Railroads and Clear Cuts. Some people may have seen the book. But basically, it's about how the railroad corporations were given a couple 100 million acres of land back in the late 1870s, or late 1800s, to actually lay track for the railroads across the United States. So companies like Northern Pacific Railroad were given 40 million acres of land by the U.S. government in a track 100 miles wide, running from the Great Lakes all the way over to Puget Sound. And the book, Railroads and Clear Cuts, was about how this land, which was once given to the railroad corporations, was now being used by the timber corporations, who of course were the subsidiaries or the folks that came after from a corporate sense from the railroad corporations that had been given the land. And so, long story short, the meeting was called with a bunch of major environmental organizations with their heads who were sitting around a table with Derek and me and John Osborne. And we were talking about what to do about this situation. We had all this land and it was now being clear cut, environmentally devastated. What do we do about it? And the major environmental groups that were sitting around the table were saying things like, well, we need to appeal these permits, or we need to sue the railroad companies, or we need to do this and that. I remember looking at Derek and saying, why don't we just sit on the land? If it's being held illegally, why don't we just adverse possess it, right? And just go in and take it over, sit down on it, and then force the railroad corporation to try to eject us, and then at least raise the issue in a manner that was commensurate with the way that the land was taken in the first place. And I remember what happened next was something one of our organizers calls sphincter tightening. And so around the table, you could almost hear it happening, right? And nobody wanted to touch it, and it was too radical. And I'm reminded, we're almost the sphincter tightening folks at this point, because a lot of these meetings that we've been in with mainstream environmental organizations has always been pretty much the same, which is we talk about how our activism is not commensurate with the problems that we face today. That our activism is about pressure politics. It's about trying to influence somebody important to do something for us. But it's not about us taking control of our activism ourselves, Understanding, much as Derek has written about, giving up hope that someone's going to descend down to the planet to help us, that the Sierra Club's going to do it for us, or beings from Alpha Centauri are going to come down and assist us. That's actually about turning to each other in our communities and saying, there's no one else that's going to help us, we have to do it ourselves. And as difficult as that may be to do, that we have no other choice. And I'm reminded of how vacant, how utterly desolate liberal progressive organizing in the United States is today. every week. We get phone calls into our office. And so a couple months ago, we got phone calls from New York City. And the New York City folks are saying, hey, we want to do something about this pipeline that's scheduled to come through New York City, this Kinder Morgan pipeline, and the other pipelines that are coming through, the Rockaway pipeline and others. And I said to them, oh, what do you want to do? And they said, well, we want to organize a ballot initiative as an advisory to tell people why the pipelines are bad. And I said, well, that's nice, but if you're going to put all that work into doing a ballot initiative, why not do a ballot initiative that bans all finance companies in New York City from financing new projects that exacerbate climate change, right? I mean, why not do something real? If you're going to take the time to do it anyway, why not do something real, right? And you could hear on the end of the phone, it was sphincter tightening time, Because people were saying to themselves, oh, we can't do that. That would be illegal. It would be unlawful. It would be unconstitutional because you're taking their property. Well, fuck it. It's time, right? Another call came in a couple months ago from a community just north of here in California. And folks said, well, we're really tired of these foreclosures that the banks are doing because they're foreclosing property all over our community. And they said, we want to do something. I said, what do you want to do? And they said, we want to put a ballot initiative on the ballot that actually asks the banks to come to a meeting with our mayor so that we can talk to them about doing something about the foreclosure problem. And I said, well, if you're going to do the ballot initiative, why not put something on that bans all foreclosures for 6 months after default occurs, right? Or a year, or something binding on the banking companies, right? And the mortgage companies that are operating there. And again, what we got on the other end of the phone was this, oh, we can't do that, right? We can't do that. That would be unconstitutionally illegal and unlawful and everything else. And so I think a majority of the work that we do, which I'm going to talk about this afternoon, where we started, where we're now at, what change we think has to occur here, because we think everything has to be rooted out. We think something has to be built anew here in the United States. And we think the only thing stopping that from happening is our own brains, that we're convinced that we can't. And the corporations have concocted these legal doctrines over the past 200 years so that we run up against them. The problem is not the corporations. The problem is our own government. The problem is our own state. The problem is the apparatus of law that's been put into place. And so what we do is we explore that with people. It's been very exciting over the past 10 years. We explore it with people, and then we start stopping it. That's what we do. And we run right into the maw of all that law because we think you have to. You can't stay outside of it and say we're not going to break the law. You actually have to break it. It's what the other social movements and political movements in this country has done. So in terms of the sphincter tightening quotient, we were on the opposite side of that for a number of years. When we were in law school, before we founded the law firm that became the Community Environmental Legal Defense Fund, we believed that the solution was, in the United States, to environmental degradation was to enforce the nation's environmental laws. You're taught in law school that the environmental laws in the United States are so good and so effective that we've exported people out to other countries to replicate our environmental laws in those other countries. And so in law school, when you're looking out the window and you see this widespread, complete, total environmental devastation of certain areas that have been targeted for toxic waste incinerators and different projects in this country, that you think to yourself, well, it can't be the environmental laws that are the problem. It has to be the fact that we don't have enough people enforcing the environmental laws that are the problem. So back in the early 1990s, we framed the problem as not enough lawyers, right? That there weren't enough lawyers in the United States to actually enforce these laws on behalf of the natural environment, on behalf of communities. People may not know this, but when you need legal assistance today in the environmental field, my colleagues and peers in the for-profit law firms are now charging about $1,000 an hour to look over a permit, to talk with a community about doing something about some project that's coming into their community they don't want. And so, and the numbers are still pretty much the same today as they were 20 years ago, which is there are only 200 full-time public interest environmental lawyers in the United States today. 200 full-time public interest environmental lawyers in the United States. And so coming out of law school, what we said to ourselves was, we'll create some more environmental lawyers. That was our solution to the problem. And so we set up shop. It was called the Community Environmental Legal Defense Fund, and we vowed to provide free legal services to communities that were under siege, from toxic waste corporations, from pipeline corporations, from landfill corporations, you name it, we assisted. At one point in Pennsylvania, where we got our start, we were assisting over 300 different community organizations to fight specific projects that were coming into their communities. And when I look back, adoringly, on those early days when we hung out our shingle, and when you hang out your shingle and it says free legal services, you can imagine how many people line up overnight. It's like concert tickets, buying concert tickets to get services. And so we had these groups that were coming to us to say, we want to stop this thing coming into our community. And that help that we delivered to those folks would all come in the form of a phone call. And the phone call would come in, and it was from the community group. And when I look back on these days now, for the 10 years that we wasted in the permit regulatory arena, trying to stop projects through a system of environmental law that was never intended to stop the projects in the first place, right? That all we can think of is a movie called Groundhog Day, right? Anybody ever see Groundhog Day? For folks that haven't, it's got Bill Murray in it. He lives the same day over and over again. He tries to figure out how to get out of that same day over and over again. And we live that day. And that day begins with a phone call coming in from the community organization. And the community organization says, we have a 20,000 head hog factory farm coming into our community. Increasingly, we have 5 corporations that want to frack our community. Or we have a corporation that wants to put a pipeline through our community. And the call would come in and people would say, we've met and we don't want this thing here. It doesn't fit our definition of sustainable farming or sustainable energy production or sustainability in any sense. We don't want it here. We just want to say no to it. To which we, as the lawyer experts, the environmental lawyer experts, had to inform them that unfortunately they live under a system of law, as do you and as do I, that prohibits communities from banning certain legal uses, right? Now, I'm not here to open up, Pandora's secret box to anybody about what the law is. If you talk to the corporate boys, you talk to the environmental boys, everybody agrees that your community, the place where you live, you're prohibited from banning a legal use, right? What's a legal use? Well, the courts have defined legal uses as ranging from everything such as toxic waste incinerators to factory farms to low-level radioactive nuclear waste facilities, disposal facilities, anything you can imagine, fracking, landfills, toxic waste landfills, land application of sewage sludge, anything that has a state permit to operate. So if the state agency has issued a permit to that facility, given state approval for it, in other words, issued the permit to that corporation, that your community cannot prohibit that use, okay? That's the law. And so what the person on the other end of the phone would generally say is, oh, well, these guys are the experts, they're the environmental lawyers, so they would say to us, what can we do, right? And that's where it gets dangerous, because you're allowing the law to define your options. So the group would say, what can we do? And we'd say, well, you're in luck, because what we can do is assist you to appeal the permit that's been granted to the corporation, right? Well, the permit that's been granted to the corporation has been granted to the corporation under permit guidelines that in most cases were written by the very same corporations that the regulations are ostensibly supposed to permit, right? That they write the laws, they write the regulations, right? So the development corporations write the development regulations. The waste industry writes the waste regulations. If we think that there's anything in there that they've written that we can use to actually stop them from doing what they're planning to do when they wrote the regulations in the first place, we are insane. Right? It's the definition of insanity, doing the same thing over and over again and expecting a different result the next time. But it's what our activism has been in the environmental field for 40 years. We've become experts in it, right? For 10 years, we did it. And the way we did it was the same way other environmental lawyers do it, which is that a permit gets issued. You get a copy of the permit application. You get a copy of the regulations that govern how the permit is issued. And you get into a dismal little back room and you study the permit and you study the permit application. And your argument is that something's missing or that something was done wrong, right? That the state never should have issued the permit application in the first place. And then you go in front of a judge, which we did quite often. And we would argue to the judge, Your Honor, section little 2, little c, little d, little Roman numeral I, little 2, little e, little Roman numeral 2, little c, wasn't complied with. here because it's the wrong signature on the permit application, or the bond isn't enough. They had to post some kind of bond, or something was missing, a page was missing in the permit application, whatever. And most of the times the judge would agree with us. He'd say, Mr. Linzey, you're right, under little 2, little c, little d, right? And I'm going to overturn this permit, right? And what would happen next? Well, the community group would have a victory party. And they'd invite us back to their house, and we'd have some beer and wine. People would pat themselves on the back, and they'd say things like, the system works. We found a lawyer. We had a problem in our community. The lawyer said the right things. The judge agreed. Now we're not going to get the factory farm. We're not going to get the pipeline. We're not going to get the frack well. We're not going to get whatever we were working to stop with in the community, stop in the community. Well, what would happen next? Well, the corporations come back, right? And this time they come back with a new and improved permit application, right? I had lawyers for the largest waste management corporations in the United States come to me and thank me for finding gaps, omissions, and deficiencies in the permits because it allowed them to bill more hours to complete the permit applications on behalf of the corporations, right? Didn't just happen once, happened a lot of times, right? So we went through this process with groups as they were fighting their various things. What would happen? Well, the corporation would come back, the community group would come to us, and they'd say, Mr. Linzey, we need you to do that jujitsu again that you did the first time around to get the permit knocked out. And eventually we would have to say to them, we're sorry, there's nothing we can do for you because all of our levers are now gone. We don't have anything left to use to try to stop the thing. And what would happen next, of course, you'd be driving down the road in the community that we were assisting, and there would be a toxic waste incinerator or a factory farm. We came to a point where we began to understand that we weren't stopping shit. And in fact, the environmental regulatory regime is not about stopping anything at all. They're not called permits for nothing. They're about permitting what otherwise would be an illegal activity through the state, right? That's what permits are all about. That's what that state process is all about. Now, I thought that people would be interested in actually that point of view. We had a win-loss record of something like 120-3 going through the regulatory process in front of these administrative law judges. Yet, if you set foot in the communities that we were actually assisting, you would find no parallel between the win-loss record and what was actually happening to those communities. But one thing, it became very clear to me at that time that many people in certain political constituencies didn't care. The liberal progressive community tended to not care. We got invited to the White House by Al Gore for Environment Day one year as one of the most successful law firms in the country. And we got funding and we got recognition, we got paid attention to, everything anybody would want in an environmental law career. But all they cared about was the win-loss record. They didn't care about what was actually happening in the communities. And so two things became apparent to me at that point. I'm pretty thick-skulled, so it took a while for it to get through. But a woman named Jane Ann Morris said something to me at about that time that has stuck with me ever since. And she said this: the only thing that environmental regulations regulate are environmentalists. The only thing that environmental regulations regulate are environmentalists, because they make us predictable as to how we oppose the particular projects that are coming in. It's a script that's written for us, and we follow it to the letter, right? The other thing I thought, at least, was that we were costing these companies money. You know, the Weyerhaeusers and the Monsantos and other corporations that were doing permit appeals over. And it turns out, under the US tax code, that the monies they spend on the permit defenses is tax deductible, right? Under the structure of law itself, it's tax deductible. No, that's true. I wish it were a joke. So what happened to us? Well, we started to turn our back on the regulatory system. We decided that we hadn't gotten into environmental law simply to help corporations build better permit applications, which was essentially what environmental law is about today. That's what it is. It's fighting within a certain script that you've been given by someone else who has no interest at all in what actually happens to your community itself. And so we changed the way that we do our work. And the reason why we changed was because we started getting phone calls from South Central Pennsylvania. For folks that haven't been in Pennsylvania, James Carville's joke about Pennsylvania is that we have Pittsburgh on one side, Philadelphia on the other, and Mississippi in the middle. It was in that rural conservative slice of central Pennsylvania that something fascinating started in the late 1990s, and that was factory farms and factory farm corporations started to move into South Central Pennsylvania, and a lot of them. So some of the counties in South Central Pennsylvania were faced with between 25 and 50 new corporate factory hog farms coming into that part of the state. Those folks, knowing that those factory farms were coming in, began to pass local laws that essentially regulated the cost of disposing of liquid manure from the factory farms to make it prohibitive. So if you wanted to put in a new factory farm, it made it financially prohibitive for you to do so because you had to ship your liquid hog manure, not to get too detailed, but you had to ship your liquid hog manure someplace else, which was cost prohibitive. The big corporations, Smithfield Foods and Hatfield Foods and other companies that wanted to come into South Central Pennsylvania, they did what corporations do, which is they went to the legislature and they wrote a bill called the Nutrient Management Act. What the Nutrient Management Act did was overnight, and in Pennsylvania they passed it at about 2 in the morning. I'm not sure when California legislature does their best work, but in Pennsylvania they do it at 2 or 3 in the morning. They passed a law that preempted all of those local ordinances from being enforced. So you had 200 communities that had thought they protected themselves by going through the regulatory process, and as it turns out, with the corporations going to legislature, simply overriding it with a preemptive law, that it left these 200 communities unprotected from these factory farms coming in. They turned to us and said, well, what can we do? We want to do something here. And we said, there's nothing you can do because you've been preempted by the state legislature. And they said something that has stuck with me to this moment, which is they said, that's unacceptable. Right? And we said, well, if you do something like this, you're going to get sued. And in fact, at about the same time we were talking to those communities, we started getting a different tenor of phone calls into the office. And the different tenor of phone calls that we got into the office were about people in communities who were unwilling to live within the regulatory regime anymore. And that's where it got pretty exciting, because the phone calls would come in, and we finally were Bill Murray breaking out of Groundhog Day. Because the phone calls would come in and somebody would say, hey, we have a 15,000 head hog factory farm coming into our community. We don't want it. We want to stop it. And we would go into our speech about, well, you can't because this is the law. And if you do, you're going to get in trouble. And they, instead of going that direction of accepting the law as it was, they started asking questions. And the questions were very short and very simple. And the first one was when we said, well, you can't prohibit illegal use. You can't ban illegal use at the community level. They would say, why? Why can't we? So we said, well, I'm glad you asked. The reason why you can't is because corporations in the United States have the rights of persons. They have constitutional rights. So Monsanto and Walmart have the same constitutional rights as you do, right? So if you pass something that bans illegal use from coming into your community, you can get sued by the corporation. And the corporation will contend that you're violating their corporate constitutional rights. Specifically, the Fifth Amendment to the U.S. Constitution, which is a right that you and I have, but also that Walmart and Monsanto have, says that your community government can't take their property without paying them for it, right? So if you ban the factory farm, you got to pay them the value of the factory farm's operation. That's how the law operates. That's how the Fifth Amendment operates. And because corporations are persons under the law, they can exert that right against your government, against you in your community. That's how corporate rights work. And it gets worse. They can not only sue your community to overturn the law that you've adopted, but they can sue your community for future lost profits as part of that Fifth Amendment construct. So we'd explain that to these folks that were calling. We would say, this is the situation, this is what can happen to you. And they would ask the next question, which is, why? Right? Why do corporations have constitutional rights? Well, we said, we're happy you asked. They have constitutional rights going all the way back before the U.S. Constitution, right? All the way back to England. Church corporations had some personhood rights. What happened with the U.S. was we took that concept and began to develop in the United States in the 1800s. The courts began to grant corporations certain constitutional rights that they could then use against our governments. And that's why you're faced with corporations that could sue you if you attempt to do something at the municipal level against this particular project. And they would say, why? And we would say, well, it's because the U.S. Constitution is not a particularly democratic document, right? When people extol the Constitution, they extol the Bill of Rights. It's what they know. It's what we're proud of, the Bill of Rights, right? The amendments to the Constitution, the rights basis. But when you actually read the text of the Constitution, it's got some awfully anti-democratic stuff in there, right? I mean, the president's not popularly elected. In the beginning, the US House was not popularly elected because there were property qualifications for people. The founders were not big fans of democracy, right? You know, you got Tom Paine and Tom Jefferson and others out there, but the bulk of the founders were not happy with democracy. They wanted to make sure the mob couldn't rule. They wanted to make sure the majority couldn't necessarily make the rules. And it's ingrained in the constitutional text. It's not just us saying it. It's other people have said it. Other people from other countries, legal scholars, have said the US Constitution is one of the least democratic governing documents on the planet, right? So the Constitution itself puts certain rights above others in a big picture sense. It puts rights of property and commerce above the rights of people, communities, and nature. When you look at the constitutional construct, that's what it does. You won't find nature mentioned. You'll find people mentioned, but only as bonded labor, just as slaves, right? And labor itself isn't mentioned at all. So workers in the workplace, not mentioned at all. What's mentioned a lot? Property and commerce, right? Protected in the Commerce Clause and other provisions within the US Constitution. To which the communities at that point, after an hour-long conversation on the phone, would say, why is that, right? And we'd say, we're so happy you asked. And the answer to that is English common law. That there was English common law before there was the US Constitution. The English common law is about England and other colonizing countries not only taking other places over physically, but actually imposing a system of law on them, right? And that system of law favored, guess who? The colonizer, right? That was the system of law that went into place. Our boys, the founding fathers, whose slaves were doing their underwear outside the Philadelphia Constitutional Convention Hall while they were writing the Constitution, thought that English common law was the best thing ever invented, right? They had the law books, most of them were lawyers, and they wrote English common law directly into the US Constitution, right? That concept of property and commerce above people, communities, and nature. That's the DNA of this country, right? When a pipeline is forced into a community, it is constitutional. May not be moral, may not be ethical, may not recognize the right to local self-government, but it is constitutional. Because constitutional does not necessarily mean democratic, right? And so we'd say that on the phone openly without getting arrested. And the folks on the other side of the line would say, well, why is that? And we'd say, we have no idea why that is. You know, it goes back to the Nile or Egypt or someplace like that. But you guys have to deal with the what is, right? And the folks in central Pennsylvania, because they were faced with such an immense harm coming in. Most of these folks were farmers and rural elected officials who had roots in the farming industry. They said, enough, right? And it's to those people that we gravitate to nowadays, are the folks that say, enough. We say, you're going to get sued. They say, we don't care. We say, you're going to get sued and you're going to go bankrupt. They say it's better to be bankrupt than to have a polluted, endangered environment within their community, right? We think what's happening is that finally the cost of doing nothing is becoming more expensive than the cost of doing something, right? And so what started to happen in South Central Pennsylvania was that communities began fighting, but not fighting in the permit system. They began engineering a different kind of system where they were writing the script, not the corporation anymore, but they were writing the script. And they began making law locally that targeted the corporations, right? They said the problem is not factory farms necessarily. It's not the air pollution, the odor pollution, everything else happening from the factory farms. It's actually the corporatization of agriculture itself. That you have these corporate actors who have corporatized agriculture, and we need to go after them. And so what they did with our help was they drafted new laws that banned corporations from farming within those municipalities, right? Framing the problem not as the regulatory excess stuff. It's not that the permit conditions aren't being enforced adequately, but that the problem is something different. It's structural. And that structural problem is that we need to get corporations out of farming, right? One place, Wells Township in central Pennsylvania, 500 people, passed the law. They became the first ones in 1999 to pass that law. Small community, 500 people. The corporations that were trying to force factory farms in the community, they took a look at the law, said this is brand new and novel. We don't want to spend the money to challenge it. We'll go someplace else. And they left the community, right? Other communities started to adopt these laws. And in fact, outside of factory farming in Pennsylvania, we had a problem with land application of sewage sludge. And not to get into too many details, but today, everything coming out of centralized sewage treatment plant, which is everything that goes down the toilet or down the sink, ends up in a waste stream that eventually is, in most places, applied to farmland where we grow our crops or feed livestock for human consumption. Communities in Pennsylvania were not getting hit just with factory farms, but with sludge. And so they came to us and said, can you actually draft ordinances that would deal with corporations spreading sludge? Because it turns out that there are 3 corporations that control over 60% of sludge industry in the United States. And we said, sure. And those folks started passing those ordinances as well. Pretty soon in Pennsylvania, we had 10% of all of the rural local governments who were passing anti-corporate laws that were going after the corporations, not just after the permit and regulatory stuff flowing from those activities that were seeking to be permitted. It was at that point that the state had to become involved, right? Because at some point when you're taking on the corporations will deal with you for a certain amount of time, but then they turn to the apparatus that they have to swat you down, which is the state itself, the governmental structure itself. And so in Pennsylvania, what happened next was that the Pennsylvania legislature passed a law, and it was called Acre. And Acre made it a crime to pass these ordinances. Okay? So the state law made it illegal to pass ordinances that targeted corporations that were involved in agribusiness. Okay? A lot of people came to us and said, oh, well, we're sorry, your whole plan, your whole project is now down the tubes because the state has come in and said you can't do this. To which we said, we think that's great. And we think it's great because up until then we've been telling people, we've been saying to people, it's not the corporation. The corporation is just the front. The corporation can't do to you what it's doing to you without your own government enabling it to do so. Right? Corporate rights are not God-given. Corporate rights come from government. Your courts have recognized that corporations have rights. It's government action that gives it to them. It's like a punching glove, you know? A boxing glove. When you go in, the corporation puts on the boxing glove. The boxing glove is the state. It's the law that's been created for the corporation to enable it to do what it does in your community, right? So what we had in Pennsylvania was these communities began rising up. They began resisting through the passage of these local laws because they said, we're going to take the law back. We're going to occupy the law, right? And what made it even more amazing is this was not progressive liberal folks. These were rural conservative people saying, fuck you, we're going to take the law. It's ours. We're going to use it, right? And what happened next was that the state government started sending people in to these places. They would send their attorney general in, their assistant attorney general into these places that were passing these laws. Because Acre, believe it or not, the state law that was passed, not only said it's illegal to adopt these ordinances, it said to the corporations, all you have to do is pick up the phone and call us to come in to get rid of these local laws. And if they don't repeal the local laws, we will sue them in the name of the state with taxpayer monies, right? So if you're a corporation, you know, you've been running around trying to put out all these little fires. Now all you have to do is pick up the phone and you call the Attorney General's office. And the Attorney General dispatches someone into the community to say, you can't do this. And if you do it anyway, we're going to sue you in the name of the state, right? We said, this is great, right? We've been telling folks it's not the corporation, it's the state itself that's the problem. You got to change the state itself. You got to change the structure of law itself, right? It was difficult to get through to people until the assistant attorney general started showing up in their communities, right? So in this one small community, East Brunswick Township, way out rural northeastern Pennsylvania, the assistant attorney general shows up. And he stands in front of the elected officials and says, you can't do this. You can't pass these laws. To which the women who the bulk of the group was women, walked up to him and physically escorted him out of the building. Right? They said, thank you, but we don't have a problem here. We've passed a law that bans sludge application here in the municipality. We don't need your help. Thank you for coming. You can go home now. And they escorted him outside. The problem was the Capital newspaper in Pennsylvania had a reporter and a photographer there. And they snapped a picture of the Assistant Attorney General being escorted out of the building. And it made the front page of the Capital newspaper the next day, right? What happened 24 hours later? The state sued them, right? State sued the community. What happened 48 hours later? A community next door passed an ordinance prohibiting the Attorney General from exercising power within their community, right? It made the case for us. If the activism is done in the right frame, the system illuminates itself. It's a beautiful thing because we don't have the power to do it otherwise. We have to pull them in. We have to create the script that pulls them in. Because most people think we live in a democracy, right? When you speak to groups, we don't live in a democracy. What do you mean we don't live in a democracy, right? They think that the system that we have with the corporate rights and the preemption stuff and municipal subordinacy and these doctrines that we deal with in our work, they think that that's democracy operating, right? So most citizen groups, when they go through the permanent appeal process and they lose, they go home. They wrap it up. The judge has spoken. They put all their faith on the judge. All the judge is doing is interpreting 200 years of corporate law. That's what the judge is doing. So why would we give validity to the judge in a court who's only interpreting law that's been drafted by someone else other than us, basically to divest our communities of any power, right? That's the question. And then the boys did something else, which is they sued one of our communities. So the agribusiness corporations came in and they sued one of our small communities. And they said, you can't ban agribusiness corporations from farming here in this community, right? You can't do it because it violates our constitutional rights. Under the US Constitution, corporations have equal protection rights, which means you can't treat agribusiness corporations differently from family farmers. If you want to protect family farmers but not agribusiness corporations, you constitutionally can't pass a law that distinguishes between the two, right? 14th Amendment equal protection doctrine. You can't, right? And so the lawsuit that came and said, you're violating our 14th Amendment equal protection rights because you're trying to distinguish between family farmers, which you're supporting, and corporate farmers, which you are not. The lawsuit comes in. We've been trying to talk to these folks about corporate rights for the last couple of years, that you can pass these ordinances, but corporations have constitutional rights that they can use to sue you in the courts. And by and large, most people's eyes would just glaze over because they say, oh, corporate rights, that's something you learn in law school or something, you bring here. We don't need that. We have a democracy here in our municipality. We've passed this law. We're going to enforce it. We don't need to deal with that corporate rights stuff. Lawsuit comes in, and on the front page of the lawsuit, it says, we are corporations. We are persons. You violated our 14th Amendment constitutional rights. Right? That page got faxed all over the state, right? Because the environment had been created where people could actually see it happening, right? See it in front of them on an issue that they cared about in a community where they lived. Too often, the way our brains work is that you can't take examples from other places and apply it to communities elsewhere because people's brains reject it. They say, oh, that's just how it works in Arkansas, right? Or that's just how the law operates in Illinois. Or that's not the same fracking situation we have here, right? It's too horrific to think that the DNA of this country, constitutionally, is about favoring property and commerce over everything else, that our brains want to reject that it actually works that way. And so people kick out the stuff that doesn't vibe with that doesn't jibe with what they have in their brains on the constitutional stuff. And so going through it with them in their community on an issue they care about has been the most important thing to developing this type of activism. What was exciting to me was once that fax went out, once that information circulated in Pennsylvania, that the next thing we got was a phone call from a small township in the northwestern part of the state. And they said, we understand this corporate rights stuff that's happening, and we want you to help us fix it. We said, okay, we're all ears. How do we fix it? And they said, we want to pass an ordinance locally that strips corporations of those constitutional rights, right? So we said, you can't, right? U.S. Supreme Court has said corporations are persons. You can't change that status at the local level. And they said, my favorite words, we don't care. Because if we allow corporate rights to be the construct here, if we allow them to be in place, it doesn't matter what we pass. It doesn't matter what we do, because we are always overridden by that structure of law that gives corporations superior rights to us. And for our interests here, if we can't stop a Walmart from coming into the community, we can't build sustainable downtowns, right? If we can't stop pipelines from running through the communities, we can't create sustainable energy futures, right? If we can't stop fracking, we can't force a turn away from fossil fuel production and use, right? If we can't say no, it all falls apart, right? And so what people in these communities have been saying for a while is, how do we say no that sticks? How do we actually go after the structural doctrine stuff to begin to overturn it? And when I give talks at conferences, sometimes, I say to folks, look, there are two ways to change things. One is you can write letters to your congressman and say, dear congressman, we think that corporate rights should be overturned, right? Or dear Obama, we think you should do something about corporate rights, right? Our activism for the past 40 years has been about pressure and influence. It hasn't worked. We are in a worse situation now than we were 40 years ago when the major environmental laws were passed in this country. Something's not working. You have to force the change. You have to force the structural change to occur. And so in Pennsylvania in 2002, the first community adopted a local law that stripped corporations of constitutional rights at the municipal level, right? First corporation said, we're not going to do that here. Since then, close to 200 communities across the United States have adopted similar laws, right? And these laws all take the form of a local Bill of Rights. So it's people hijacking their municipal system of law, seizing their municipality, the communities where they live, to actually seize the system of law to drive it upwards against the state and against the corporation. That's what's happening in these communities. And they're doing it in a way that ties it to a single issue that's important and relevant to that particular community, and that contains a Bill of Rights that guarantees clean air and clean water, a right to a sustainable energy future, a right to sustainability in general. And that begins to get rid of this superstructure of doctrines that are in place that keep us from moving towards sustainability because we don't have local self-government rights in the United States today. So, we'll get to that at the end. So each community is different. Each community moving forward, we have close to 200 now in these 8 states moving forward. And those communities in places where there's a critical mass in the state, like in Pennsylvania, we have 100 communities that have passed these community rights ordinances, are now coming together into community rights networks, which are now beginning to propose state constitutional change. So in Colorado this past year, the first constitutional amendment proposal was put forward. It would actually begin to legalize the ability of communities to adopt these bills of rights ordinances that strip and redefine corporate rights within their own communities. So that's the next stage of the work at the state community rights network level. And then 3 weeks ago, those states joined together, those communities in those states, to create the National Community Rights Network, to begin working on federal constitutional change, right? We think that you have to rip it all out. You got to build it from scratch. And part of the building from scratch piece is the rights of nature. Amazingly, as part of these local bills of rights that have been passed in these various places, communities are beginning to recognize ecosystem rights, okay? That ecosystems and nature are not property, that they are not property under the law, but they actually have rights to exist and flourish of their own. It's an ancient concept. The indigenous communities have recognized nature as something other than property for the last 5,000, 10,000 years. Industrial civilization has thrived on the fact that ecosystems are property and don't have rights, right? Ecosystems themselves, the more you can own under our system of law, the more you can destroy. So you have a 10-acre piece of land that you have a deed to. The deed carries with it the legal authority to destroy the ecosystems on that piece of property. We have a property-based system of environmental protection. It's why everything's going to hell in the first place, because it's based on the wrong predicate. It's the wrong base, wrong premise. And so these communities are beginning to pass ecosystem rights provisions that recognize that ecosystems have rights, that they're not just property. Social movements of the past, the abolitionists, the suffragists, have dealt with exactly the same situation. In the 1840s, it was not a crime to murder a slave because a slave was property. You paid property damages to the owner, right? Loss of use for the slave. But the slave was not a person under the law. It didn't have rights. It only had rights derivative through the slave's owner. For women in the 1800s, rape was not a crime. Rape was a property damage crime. You paid property damages to the husband or to the brother for rape. It was not a criminal offense because women were not persons under the law. They had no rights. They were property under the law. Today, ecosystems and nature are property under the law. You can own them. We think that a big part of the transition that has to take place is to shift ecosystems and nature from being property to being rights-bearing. What's exciting to us is that in 2003, the first community in Pennsylvania passed a rights of nature law. It was a little place called Tamaqua Borough, just north of Philadelphia. After they passed it, others started passing it. It's now become part of the ordinances that are passed by these close to 200 communities in 8 states. But then we got a phone call from the Pachamama Foundation, which is located here in San Francisco. And the Pachamama folks were working with the country of Ecuador to draft a new constitution for the country of Ecuador. So Pachamama was an advisor for that process, and they put us in touch with the Ecuadorian Constitutional Convention to talk with them about making Ecuador the first country to shift to a rights-based ecosystem protection system. Okay. In 2008, they actually put language into the constitutional draft that would convert ecosystems and nature from being property into rights-bearing systems protected by constitutional provisions, and it was overwhelmingly ratified by the people of Ecuador in 2008, making Ecuador the first country to begin the system of rights-based ecosystem protections. What we've been following carefully since then is the cases brought as a result of those constitutional provisions, right? And the first case that was brought was filed by the Vilcabamba River in Ecuador. Because in these cases, the plaintiff is the ecosystem, right? Not a person. Under current environmental law, of course, you have to be a person, and you're bringing a lawsuit essentially to protect your exploitation of the resource or the ecosystem. But in these cases, the plaintiff is the ecosystem. It's hard to get our brains around it sometimes, but that's what happened. And the Vilcabamba River won, right? Now, enforcement is still an issue that they're dealing with, but as a legal precedent, a judge held in favor of the river as the plaintiff in the case. Just last week, we filed the first pleading in litigation on behalf of the Little Mahoning watershed in a place called Indiana County, Pennsylvania, where a oil and gas corporation is trying to force an injection well into a municipality called Grant Township. Injection well is to take their frack wastes and dump it down the injection well, which is what they do with the brine and the oil and gas wastes, is to dump them into the ground via these injection wells. The township, with our help, has adopted an ordinance banning injection wells and also providing for the rights of ecosystems and nature within the municipality. The oil and gas company sued the township, and as part of the lawsuit, which we're representing the municipality, we have now intervened on behalf of the ecosystem. So it's still pretty cool to me to look at the court docket and see the Little Mahoning watershed as a party on the court docket. So that takes a little bit of getting used to. Just a couple other things to finish up. We have in Nepal and India, we've been working with the Nepalese. They're putting together a new constitution as well. They're trying to follow what's happened in Ecuador by putting rights-based environmental protections in. Just 2 days ago, environmental lawyers and community organizations came together to form Rights of Nature network within the country of Nepal to begin putting a right to climate into the Nepalese constitution. A legally enforceable right to climate into the Nepalese constitution. And a right to climate has been written into some of the ordinances that we work with as well, in terms of provisions here in the United States. The one thing that that gets to me anymore with the progressive liberal community is that we continue to talk about pressure and influence politics. We do events aimed at trying to get someone to do something. We think that if somebody important, that we get their ear, that will solve the problem. I was in a meeting the other day where folks in a community are trying to stop sand mining and gravel mining from occurring in their community. And they kept saying that they wanted to get to Elizabeth Warren to get her informed about what was happening, to which my cohort in the meeting said, "What do you think Elizabeth Warren is going to do for you?" Right? Do you actually think she's going to stop the sand mine that's coming in, that the company is putting in? And so I think people still have this thing in their heads where they think that your elected officials are actually going to assist you, that the environmental groups are going to assist you, that someone else is going to come in to do what you need to do in the first place. It's not going to happen. And the other thing that drives me crazy is people say, well, we just want a voice. We just want to be able to say, have our say to the corporation at the town meeting, or have our say to the local government. We just need a voice. We just need a voice. We just need a seat at the table, right? That's what they say. We just need a seat at the table. We own the fucking table. It's our table. We decide who gets served, who gets a beverage, who gets utensils. It's our table, right? It's not about having a seat at the table. It's about making the rules. It's about writing the script. It's about those things. And it's about looking at structural change in the United States with a coming to grips that we have a system of law that is not democratic, and that we actually need to change it to create a new system that is. And along the way, give birth to this right to local community self-government, and to understand that when we say community, it doesn't just mean the humans within the community. When we talk about community self-determination, it doesn't just mean us, right? It means the rivers and the streams and the forests. It means self-determination for them. And it means finally getting skin in the game. I mean, I go to conferences all the time and I hear indigenous peoples come and pour their heart out about how they're on the front lines, and they're the folks doing the frontline work. And they're right. They've been doing that for 500 years, longer than that. The folks that haven't been doing it is us. We have not been doing it, right? We stand on the sidelines because we're not the ones doing it. They can't do it themselves. They've been slaughtered for centuries. The white communities have to step up to the plate. And they have to do so in a way where they begin seizing their own communities to turn it up against the system that is. The corporate boys are not the problem. Our own system of government is the problem. And until we come to grips with that, we can't help anybody, and we can't stop shit. And that's what has to happen. I'm sometimes amazed when I wake up in the morning that anything's happening at all, right? That the walls are so tall and the mountains are so high to climb that it's amazing to me that any of these communities are actually taking them on. But they are, right? They're standing up to do it. And we're looking for more that will do it. And we're looking for more that will take it in a different activist direction than we have for the past 40 years, where we've been spinning our wheels. Thank you.